Major breaking news in the VanDerStok case out of the Northern District of Texas. This is the legal challenge to the so-called Joe Biden ghost gun rules dealing with partially created frames and receivers. This is the one that went to the Supreme Court last month, and the Supreme Court enjoined what was known as Vacatur. Well, there was a major ruling today in this case by the Federal District Court Judge Reed O'Connor that has now enjoined the ATF and the Department of Justice from enforcing its rules associated with weapons parts kits and partially created frames and receivers as applied to the intervener parties in this case, specifically with respect to Defense Distributed and Blackhawk Manufacturing Group doing business as 80% Arms. So stand by. We're going to talk all about this in 1 second. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of First They Came for the Gun Owners. Pick up a copy if you don't already own a copy. All right, folks, so major decision today. We're going to get super geeky about what are known as remedies. Remember that you can win or lose a lawsuit. If you win a lawsuit, then you're entitled to certain remedies. Some of those remedies, maybe you get money. Some of those remedies, you might get an injunction that prevents somebody from doing something, or maybe it requires someone to do something they don't want to do. Anyway, that is what the notion of remedies is. You bring a lawsuit, you win on the merits of the case, and then you get a remedy. So what's going on here in the VanDerStok case, as you recall, the VanDerStok case was filed, a series of related lawsuits challenging the ATF's attempt to use regulations rather than going to Congress, to use regulations to expand the scope of frames and receivers and the scope of what constitutes a firearm under federal law. The Federal District Court judge in Texas and then the U.S. Court of Appeals for the Fifth Circuit said that the ATF clearly exceeded their authority. And then they entered the remedy known as Vacatur. Now, this is where we get geeky. The remedy of Vacatur says, and this is available under what's known as the Administrative Procedural Act. The remedy of Vacatur occurs when an administrative agency, whether it be the ATF, the EPA, the FDA, the DEA, it doesn't matter. If an administrative agency promulgates rules and regulations that exceed its authority under its enabling statutes given to it by Congress. So here in the context of the ATF rules associated with quote-unquote ghost guns, the ATF expanded the definition of firearms beyond what the statute provided. At least that's what the Court of Appeals found in the Fifth Circuit. So basically at this point, the winner of the lawsuit down below is the plaintiffs that have sued the ATF and the Department of Justice to say that, you can't do what you're claiming you can do. And the lower courts have already said, indeed, the Department of Justice and the ATF have lost. But here's the key point. The Department of Justice and Merrick Garland, as you recall, sought an emergency application for a stay of the Vacatur order of the U.S. Supreme Court. Specifically, what they said is, U.S. Supreme Court, we're litigating this appeal now in the Fifth Circuit. And we expect to litigate this appeal to the U.S. Supreme Court down the road. During the pendency of this appellate process, we think the ghost gun rule should remain in place and not be vacated under the rule of Vacatur. And the Supreme Court, in a 5-4 decision with no opinion issued, where Amy Coney Barrett and John Roberts sided with the liberals, said indeed they agreed. They stayed, which meant pause, put on hold the Fifth Circuit's Vacatur order, and as a consequence of the Supreme Court's decision to put pause on the Vacatur order, it means that the ghost gun regulations of Joe Biden that the Fifth Circuit has actually found exceed the law and violate the law, that these can still be enforced by the ATF across the country, that the rules remain in effect because the Vacatur decision by the Fifth Circuit was stayed by the U.S. Supreme Court. But that was on the remedy here. Now, what's interesting is this. So while this was going on, two very intelligent parties here, Defense Distributed and Blackhawk Manufacturing Group doing business as 80% Arms, they filed a motion for an injunction. Did you hear what I just said? An injunction. Now, this is where we get geeky. As you recall, the Supreme Court said that the order of Vacatur that vacated the entire ATF rule dealing with ghost guns was vacated. It went away for all Americans. So what the parties that had won in the Fifth Circuit did, specifically at the two intervener parties, not all the parties, but some of the parties, they filed a motion to enjoin the ATF from enforcing these regulations as to them specifically, saying that Vacatur was to get rid of the rule entirely, but even if you're not willing to do that or you can't do it because the Supreme Court says you're not going to allow Vacatur now, you can at least enjoin the enforcement of these regulations as applied to us who won the case. And that is exactly what Judge Reed O'Connor did. He entered an injunction that says that because the plaintiffs have won the case, the ATF and the Department of Justice may not enforce the ghost gun regulations against the Defense Distributed Company and Blackhawk Manufacturing Group 80% Arms. So this is a very big win. Now, the other interesting thing here is that the court points out that the Supreme Court stay only dealt with the remedy of vacator. The Supreme Court stay of the Fifth Circuit decision did not deal with other available remedies. One of those other available remedies that's inherent in a court, as opposed to relying upon the Administrative Procedure Act, is the remedy of an injunction. So the court says that they get to enjoin the ATF and DOJ from enforcing this ghost gun regulations as to these particular parties in the case, and therefore they can continue to do what they were doing before the regulations went into effect. So again, it's a big win for the parties involved, but it's not nationwide and it doesn't cover everyone in the country at this point. It only covers the specific parties involved in that case, and not even all the parties in the case, just the ones that move for an injunction. As to whether or not other people will move for an injunction down the road in this VanDerStok case pending before District Court Judge Reed O'Connor in the Northern District of Texas, only time will tell. I will say one thing, though, that one of the considerations when you move for an injunction is timeliness. So in light of that, one wonders whether or not people could move to intervene into the Reed O'Connor case down in the Northern District of Texas and get into the case and then seek to benefit from the injunction, or whether or not that would be viewed as untimely. That is a question I don't know. It may never come up, but if it does come up, I could see questions about timeliness and whether or not people waited too long and sat on their hands and thus are not entitled to equitable relief in the form of an injunction. But the bottom line is right now, right here, a big win for some of the parties down there in the VanDerStok case. Again, it's super geeky because the remedy of vacator is not available for the moment because the Supreme Court stated, but the remedy of an injunction is still available. And that's what Judge Reed O'Connor said. And we'll see what happens as this carries. I'm sure the Fifth Circuit will weigh in on this and probably do a Supreme Court at some point. But for the moment, at least, a little bit of a setback today against the ATF and the Department of Justice, and every little win we get for our home team is a big win for the home team and the Second Amendment of the Bill of Rights. And I do think this is a big win, although it's of limited application today. I think ultimately it's a big win and may have big repercussions in favor of the Second Amendment down the road. Okay, folks, hope you learned a little bit something here today. I know we got a little geeky between vacator, which is a remedy available under the Administrative Procedures Act, versus an injunction, which is available with the inherent authority of a court. Nevertheless, you do understand that only one was enjoined by the court, the other was not, by the Supreme Court, I should say, which means injunctions remain available and they can be used against the ATF. So let's see what happens going forward. And don't forget to subscribe here at the Four Boxes Diner, to follow me on Twitter at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.